My name is Rebecca Bernhardt. I'm the Policy Director for Texas Defender Service. I'm here today to talk about one issue that involves the Board of Pardons and Paroles, and that is the particular process for capital clemency hearings, or the review of capital clemency petitions. Texas has instituted many innocence-related reforms over the past several years. Changes to the procedure by which the Board of Pardons and Paroles considers capital clemency petitions would fill one final gap, or one of the final gaps, in these reforms. Based on Supreme Court case law from several years back, we know that courts will not consider innocence issues on their own accord. That when a criminal case is being reviewed post-conviction, there have to be other procedural problems with the conviction for the case to be reversed. So that leaves us with clemency as this very powerful tool to address issues that exclusively go to whether or not new information has been discovered that goes to the guilt-innocence issue when there are no other procedural problems in the case. So in 2005, there was a report done that looked at our whole clemency, or our capital clemency process, and found that compared to other states, we did not have a very robust clemency process. Texas does not hold hearings in capital clemency cases. Most other states do. The board does not meet in person to discuss cases or make its decisions. The board does not have guidelines to use in guiding their decision-making on capital clemency, and the board does not provide reasoning for the recommendation of a grant or a denial of either of a capital clemency petition. And particularly on the issue of a pardon based on innocence, that is only possible when all the court officials involved in the original case agree that the petitioner is innocent. To both strengthen government transparency and the clemency process as the last forum for review of innocence claims, Texas Defender Service recommends that the filing deadline for clemency petitions be pushed back, that public hearings in capital clemency be mandatory, that there be guidelines for board clemency decision making in capital clemency cases, that they hold a public vote, and that they make written explanations of a recommendation for a grant or denial.
Okay.
Do you have any questions?
Anybody have any questions? Thank you very much for coming out.
Thank you.